Ms. Chang said she might be a little bit late and not able to be here at 1:45. She hasn't come in, has she? And I don't know her, so, all right. So what I would like to do is have us just begin talking. We had a lot of material come in from different work group members, Mark Johnson, Eileen Fairley. Specifically, we had some articles that were sent to us as to different things we should look at. We also, Eileen provided a document we could work through to help us came in last night, help us form our thoughts. I'm going to turn it over to Dory to get her suggestions as to how we begin this conversation.
Thank you. So in some meetings past, we've talked in terms of a matrix that we lined out some options and then had general discussions about overall concepts as well as specific recommendations that might be appropriate regardless of an overall approach. The more we talked about that, it became clear that the notion of a radical departure from what we currently have in favor of splitting off into mandatory and voluntary had relatively little favor around this table. That was just the impression that I had. And that whether we're looking at the current system with maybe some specific recommendations to make tweaks or adjustments to it, or we conceive of the current system as something of a hybrid system insofar as section membership is already voluntary, then we're really just focusing the conversation at that point about whether there's any more programmatic or activity-based functions at the bar that we should consider more like the sections. Then there were some specific recommendations about, with respect to what we would all classically understand as regulatory functions, maybe this group would have recommendations to the Supreme Court about what would be some advisable adjustments to make so that the active supervision role of the court is well understood and adhered to. I saw Eileen sent some materials kind of framing those sort of discussions as well, and it's just another way to facilitate the discussion. You had Fred send a draft resolution for at least part of it, and as I see it, what you're discussing all tracks to what adjustments to our current system without kind of a radical departure from the current system. Is that a fair assessment of what you've talked about to date?
Well, some might agree and some might disagree. So those who disagree, I'd like to hear from you or hear your modifications, starting with Hunter.
Well, first of all, I would say I certainly don't disagree with how it's been portrayed. I think that's exactly right. I would say that my impression from the conversation that's taken place around the table is I think I'm probably maybe among the most forward-leaning in suggesting that we very strongly consider recommending to the court going to a different structure. Again, my impression is that I might be a minority of one on this. It certainly won't be the first time nor the last. But if that's the case, I did want to articulate a little bit further some of my thoughts behind that. Because I think it's the first big question we have to address is, do we want to keep and maintain and defend this unified system that we currently have, or do we want to recommend a significantly different approach? And then further decision points are reached based on which decision we make. So I guess I wanted to briefly preface my remarks by saying that I think there is, in many circumstances, a tendency to try and defend the familiar, and I often do that. Because we have the system that we currently have. We know it. We tend to like it. We recognize that there are issues out there. But I heard this from a number of individuals in the recent WSBA listening tour, where their initial inclination was to defend the current structure because they want to defend the organization or the profession. And I think that's a bit of a mistake, because recommending changes to the structure is not in any way throwing rocks at the profession or throwing rocks at the institution. Instead, I think what it is it's an opportunity for us to think about what is the ideal structure for this organization, for this bar at this point in our history, and acknowledging again that we started as a voluntary bar in the 1800s. We went to the current structure in the 1930s. I think now is an appropriate time for us to think long and hard about whether the current structure is the best structure, and I don't think it is, and I wanted to explain why. we came together to talk about the constitutional analysis in light of Janus and the related decisions. And people who are much smarter than I am, and I don't claim to be able to hold a candle to many of the authors that we've read from or the individuals that we've heard from, have opined that they think the current structure can survive Janus and the Janus-related analysis. I'm not quite as confident in that, but I think we know that we can reduce our exposure under that by going to a different structure. And I'm going to address that in just a moment. Something else, and one way to potentially do that would be to have the court reach out and grab or more explicitly retain some of these core regulatory functions that we've talked about, and then have other functions go toward a voluntary bar association organization. When I initially wrote to the Chief Justice asking for permission to serve on this work group, I told her that I would view this through the lens of, is it going to build trust with three specific groups: the public, the members, and the court. And one of the big picture dynamics that I see in 2019 in America right now is that people don't trust institutions. Trust in institutions is decaying. You can look at whether it's our political institutions, the media, business, you name it, trust in institutions is decaying. And so we have, I think, a particular task in front of us to try and build the trust for this organization, for the profession, with those three key stakeholders. So when we talk about building trust with the members, my impression on going on the listening tour and talking to a lot of members is that the members are really angry with this organization. I'm just going to, name the elephant in the room. I think a lot of people are really angry at us. They're not angry at the profession. They love the profession, but they're angry at the organization. And I think one of our challenges is to set aside maybe some of the current dynamics or the situation that the organization has faced over the last several years, and again, think a little bit more in a vacuum of what would be the optimal structure for us at this point in our history. But it strikes me that to build trust with the members, it would be a significant way to do so by saying that we trust you and your decision about how to spend your limited time, treasure, and talents. Do you choose to be involved in a voluntary statewide bar association, or do you not? Do you prefer to reinvest that time into your local county bars or some other specialty bars? That is a decision that we could entrust them with. And I think it's important to point out that no one is saying they don't want to be under the auspices of a robust regulatory system. Everybody acknowledges that. And what I would suggest is that that be under the purview of the courts, probably with some intermediary entity there, because I don't think the 9 justices want the day in, day out job of operating that. Another thing that strikes me about a way to build trust with the members is that, my background is the military, and the military is an institution that had the trust of the American people, lost the trust of the American people after Vietnam, and then spent a long time rebuilding that trust. And part of that was by going to an all-volunteer force. And what that did is it made the members who were in the military, it made individuals who all wanted to be there. And I think that's important. I think if you have an organization where everybody wants to be there, I think that will change the dynamics of the organization. I think it will strengthen the profession. So those are some thoughts about how to build trust with the members. Building trust with the public, I believe that there is a misperception out there that there's a fox and henhouse problem with the WSBA, and it's a false impression. As we know, it's the Supreme Court that takes disciplinary action against members. But I think if we were to clarify and make that even more clear, that in fact it is the court that has that control and authority, and have those core regulatory functions live under the auspices of the court, I think that will help build trust with the public. Some other, kind of final point here is that we didn't get here by accident. There are outside forces that helped bring us here. The legislature has shown significant interest in this. I would not believe it's ideal to go back to the legislature and say, we recommend really no changes. I'm not sure the legislature will take that as an answer. Another point is that if we effectively do nothing or kind of, nibble at the edges, we also run the risk of some judge making that decision for us.
We have someone on the phone with you really need to mute your line. We can't hear anything on the phone. So those of you on the phone, please mute. There's someone in their kitchen or something.
Silverware.
You guys in the room are interrupted by it, but everyone on the phone cannot hear you.
So I guess my final thought is that these thoughts are informed, again, by things that I've heard, by going on the listening tour, and hearing from members. there are some members who are just, again, very angry at the bar and kind of want it to go away. I'm not really talking about those concerns, although I don't think we should dismiss those concerns. I'm talking about individuals, members who care very much about the bar, care very much about the profession, who thinks that it will be stronger and a better association, a better profession, if we were to go to a different model. So, thank you. Those are my thoughts.
Eileen and then Paul.
Well, I'm not quite as far along as Hunter, but I am on the spectrum. I am closer to him than definitely than the do nothing phase. I think they're looking at, and I'd preface this by saying this is not a legal analysis. This is my opinion. I'm not a First Amendment person, but there does appear to be a way forward to maintain an integrated bar if there's a decision that that's a wise thing to do. But the path for that is narrow, and it does require an analysis of the activities, not just the labels given to the activities conducted by the bar. You know, where are statements being made? Where is there a First Amendment implication? And to, excuse me, assess those in light of Janus. With Hunter, I agree. I think we've all heard that there is a deep dissatisfaction in the bar, and I think this can be an opportunity for revitalization, but if it's done properly. But I think it can also be, if it's perceived as simply doing the same thing, but just using different language, it will be perceived pretty cynically as just another WSBA. I'm trying to come up with the word that's going to be on the web, the mess up. So I would encourage, we are going to make a recommendation to the court. Court's going to do what it wants. My recommendation is that if there's a decision to explore the possibility of maintaining an integrated bar, that the bar activities themselves be assessed in light of Janus. And I'm less concerned about the Sherman antitrust, but I think that also needs to be factored in. I encourage, I have talked with 2 former governors in the past week. I would encourage Justice Fairhurst to write to them again at this point and ask for further input. I told one of them not to be surprised to hear this. The expression to me was that earlier it just seemed too much of a muddle in order to respond effectively. But I think that we have all acknowledged the deep dissatisfaction. The email from Mr. Clark saying if we change the structure, a lot of people are going to leave, I think is an acknowledgement, and it needs to be taken into account. Members pay for everything in this room, and I think if they're not happy with how things are working, that is something that is a matter of respect, needs to be taken into account.
So I am, further on the spectrum toward not bifurcating, but I'm also very keenly interested in not tripping over obvious constitutional issues. In one of our more recent Board of Governors meetings, I floated the idea that I thought one of the best ways to stay out of trouble is probably get rid of the magazine. I think that's just an opportunity to say or write the wrong thing. Even on the Board of Governors, I don't have one iota of insight into the editorial processes of that magazine, and I would not entrust the future of the bar to, a magazine. I think that is kind of the low-hanging fruit constitutionally in terms of preventing a problem. I know that there is dissatisfaction among the members, and it is why I was elected to the Board of Governors. I ran on a platform of reforming the bar. I am one of the reformers, and I ran that campaign in 2016, 2017. I've been on a listening tour for about 20 years. I've been very involved with the Bar Association. I've been a member, a senior executive member of the Corporate Counsel section for 20 years. I gave my first CLE presentation in 1991. been involved with the business law section for a long time. So, you know, and I have a very large email list of folks, you know, like it or not, who want to hear what I have to say about what's going on at the bar and how things should be improved. If we bifurcate, the big issue is, you know, it's not that we're defending the familiar, it's the devil you know versus the devil you don't know. I much prefer to tinker around the edges and fix what I can see. And the issues that I think have annoyed the members all have to do with sort of disregarding the interests of the members and just it's our way or the highway. And really, you know, just kind of rolling out things and saying, you know, oh, here, we're listening to you. What do you think of this idea? And then the members chime in and we just do what we want to do. And that has happened repeatedly. Things get sort of steamrolled through and the members feel as though they're not listened to. That is a core element of reform, is being responsive to the members, understanding, try to understand what it is they're concerned about. They're very well-meaning folks. The members of the Washington State Bar Association are very much interested in access to justice. They're interested in being good lawyers. They're interested in doing the right thing. But they don't always like to be told exactly what to do and to think from Seattle. That is one thing that sort of grates on the nerves. And when you feel like you're so insulated from the membership and you strive to be insulated from the membership, you do get detached. So that's why I advocate strongly for continuing to have the members elect the members of the Board of Governors and to listen to the members and to be responsive to the members. An area where I would see tinkering around the edges as helpful to rebuild trust is taking a sharp eye at the budget and looking for areas to cut costs. We always just sort of increase costs. You know, I think that fixing what we have is the smart path, and it's the path of least resistance. If we encounter constitutional challenges, we can respond to those at the time. But I think that bifurcation just throws so many issues up into the air, including the likelihood that sections will see a 25, maybe even 30% reduction in membership. The sections are the lifeblood of the bar, and hacking 30% out of their membership, I don't see as is a wise way forward.
Fred.
And go back to Hunter's thoughts and comments. Before we decide whether we're going to divide, whether we're going to be integrated or not, I think it's important to put substance over form. And I do believe we need to decide what we want to do. And that's why I put my resolution out there. What is it? What are we going to carve off if we are two different organizations or not? And I proposed that the access to justice and maintaining issues relating to minority and diversity are things that we can do and that pass the First Amendment right, and we should keep those as core values, and we should keep that in our mandatory bar. I agree with Paul on, and I think I agree with Eileen and Hunter on this too. Looking at it as substance, okay, there's something that I've decided that I feel strongly as a member of the Access to Justice Board, you know, that I believe that that's a core mission. We've got to keep that in there, and that's why I had that resolution. There's other issues that we can look at, and I think we look at them substantively. I think, Paul, it was you that suggested the idea about the magazine. Looking at what the deficit the magazine is running, things could be changed to the magazine. It could be a magazine that people have the option to subscribe to, you know, to cover the cost that it isn't covered by advertising. I think we all have looked at another thing that we should talk about is a robust Keller audit. I mean, a lot of us have a hard time figuring out how the number can be so small. And if, as a litigator, if I was trying to defend that, I would have a hard time doing it. We have to show that that number is real. Because frankly, if the number doubles, that's something a litigator can say, we've doubled the number, but it's still not a huge number. And always, when you are taking responsibility for a large group of people's cash, we should be careful and look at the budget. I agree with all those things. But I want to get back to the substance. What is it that we want to keep? What is it we're going to tell the Supreme Court we need to keep? And what things, specific things, do we suggest that we need to change? And when we have the list of things that we need to do and that we think we should, well, basically it's the things we should do, because some of those things may be carving them out. When we have that, we have a recommendation for the Supreme Court. One caveat that I'll just say to my proposal, my resolution that I suggested, I put in there two things: the Access to Justice Board and the Minority and Justice Commission. I have talked to Diana Singleton a little bit about it. The Minority and Justice Commission, as I understand it, is not a WSBA piece. And so probably, and listening to the first presenter, it's the WSBA's Diversity, Equity, and Inclusion Program. And that was my error. I understood the ATJ part. So I would change that, because one is not under the auspices of the WSBA. Thank you.
I'm going to clarify that for you.
Okay.
Others who have not spoken, who would like to speak to just our approach and what we should be looking at? Anyone else? Kyle, go ahead, please.
Just briefly again, I've mentioned before that I think strengthening the Keller deduction, maybe making it a opt-in as the right approach. I disagree with any kind of major change at this point, because as Mark Johnson said before, we really don't know what the U.S. Supreme Court is going to do. And I don't think doing a radical change now, unless it serves the benefit of the Bar Association itself for other issues, is appropriate. So I would rather see, as Governor Spiegel mentions, a kind of a tweaking or adjusting around the edges, make sure that we're making improvements where warranted, but not making any drastic changes at this time, and trying not to read the tea leaves in the future as to what the U.S. Supreme Court might do. Also, just taking into account the letters from that were submitted yesterday or the day before from the ACLU and others, and also from Governor Gerbicki, that make a good argument that Janus and Harris are not going to require any kind of dramatic changes to our Bar Association. So I do think there are improvements that could be made. I think that could be made through an opt-in process, and support what Fred just said about maybe making it a more robust Keller deduction, perhaps audited. Although I struggle with that. I don't know who does the audit on an issue like that. It's not really an accounting issue. It's determining what issues are political in nature and what aren't. And that's not really within an audit, a typical audit. So I agree with maybe having an independent review of that. I question whether the audit is the right term. But again, I think a more robust opt-in, something that addresses the political activities, that would help, I think, the Janus and Harris issue. One last point, going around these listening tours, I have not been in the Seattle, Pierce County area speaking tours, but I have been in the Southwest Washington, and I echo what somebody else earlier said, is there are dramatically different perspectives coming out of different areas of the state, and some of those perspectives are that we are too Seattle-centric, and that's somewhat of the anger that people voice, is that we're all about Seattle. I don't think that has necessarily anything to do with the structure of our organization, and so sometimes just making changes because people are angry is not the right route. Thank you.
Thank you, Kyle. Anything from any of the other work group members at this time? Esperanza, and then Ms. Chang has arrived. And so after, I just want to finish out this portion, and then we will hear from Ms. Chang, and then we'll continue speaking. Esperanza, please.
Yeah, I appreciate what everybody has shared, and a lot of thought has gone into the positions that folks have on what should happen with the bar, the structure, what it's going to look like. And I feel very, very strongly that whatever it is, everybody that has spoken about where they stand or where they think they stand at this point, because we have another meeting and there might be more information that we get that might change, my mind and somebody else's mind. But the thing that's not going to change is that access to justice is going to be possible if we have an access to justice board and if we have a diversity and equity and inclusive focus on the Washington State Bar. And I think about the public. You mentioned the public, Hunter, and a lot of the public has no idea who WISPA is. They don't know the role that WISPA plays in their lives. And that's an access to justice issue. And we need to get to the point where the public does know the role that WISPA plays in their lives. And we're not going to get there if we don't have entities that are making sure that we figure out how to break that down and what is it that we need. And so when I looked at the presentation that you did earlier on the breakdown of all these programs, those are the pieces that are needed in order to be able to have access to justice. It just doesn't happen. And I talk to a lot of attorneys because I'm a program director. We have a pro bono program, and I just don't talk to the attorneys in our pro bono program. I talk to attorneys in other pro bono programs in other parts of the states. I'm not hearing this anger. So I keep thinking, well, how many people are mad? Where does this come from? As somebody from the public, and I keep hearing, well, people are mad, people are mad, people are mad, and I'm out there and I'm going, okay, what do you guys think? And well, I'm not quite sure what's going on, but we want to make sure that this happens. People are saying what they want to make sure is included. And so far, what I'm hearing is because they're in communities where they're overwhelmed because there are not enough attorneys being able to provide the services that are needed out in those communities. They're saying we need to make sure that we're providing the services. There are people that can't afford an attorney. What are we doing about that? So all those issues is what they bring up. They don't bring up that they're mad at WISPA, that they think WISPA is off, some rogue organization doing whatever the hell they want to do. So I think it's this organization is about protecting the public and protecting the members. It can't be protecting the members, period. Protecting the members is protecting the public does equal protecting the members. So I feel very strongly I appreciate, Fred, that you put forward this resolution. And I think that we do need to make a decision about what is it that we want. Are we saying that, no, we don't want access to justice? I don't think that's what's being said here. I haven't heard that being said here, but I'd like us to be bold enough to be able to say, yes, this is what we want in here, and then let's figure out what structure we're going to have.
Thank you, Esperanza.